Okay, hold on. Okay, so now I'm live on YouTube, so now people should notice that it's on. Where is this guy? I don't know. Okay, I'm just waiting for my guest to pop up, but for whatever reason, I don't know what's going on. We practiced this, but I think he may have had a little trouble with his computer, so I'm just waiting for him to get in. Okay, so I see, how you doing, Iman Perry, and I got Zonda, all right, CDA, Michael Garrido. Wait, my guest is coming in a second. We were practicing this, but hold on one second. I'm trying to make sure that he gets it. Oop. Yeah, I don't know. We practiced it. I think I just resent him the link, so I'm just waiting for him to come in. But anyway, basically, it's like this. On the Manosphere, there's been a number of topics that we were talking about, and my thing was, it's one thing to talk about stuff in an echo chamber, but it's another thing to actually get somebody who actually knows the law to, respond on certain topics and whatnot. So there was a number of things that have gone down, and I know like some people probably had questions. Now, I should say it like this. Let's see. Okay, so yeah, there's a number of questions that people have, but let me just explain it like this. First of all, yes, my guest is a practiced criminal defense attorney. And yes, he is currently working as a judge elected, but he's not. You can hear these people behind me with these shitty goddamn four cylinders making that fucking noise outside. You can hear them. They're like a block over. It's still a pain in the ass. But anyway, they're not allowed to give you legal advice. That's something you have to actually do privately with an attorney or a representative. But what they are allowed to do is they're allowed to give their opinion on legal issues. So when my guest is here, basically the questions that we're going to bring up, topics we're going to bring up, you're allowed to ask advice, but you're not allowed to ask for like legal counseling right now. Now, if you're a person who lives around here, like if you live in New York, I'm pretty sure when he comes up, we're gonna put up his website, because I think he still uses a website, if I'm not mistaken. And if you want counseling and whatnot, you do that privately. You're not allowed to do that publicly, from what I know. Because this way you can't give out advice and then somebody takes the wrong advice and then they go and fuck up and do something really stupid and then say, oh yeah, well he told me it was legal. Well, no, it doesn't work like that. So he's going to give his opinion, his legal opinion, but not legal advice. So you're not allowed to do that in public. 1 second, I'm just trying to get in contact with him. I don't know if he's having problems because we were in here a minute ago. All right, let me just try to contact him. Oh, there he is. Okay, bringing him up. Okay, all rise for the Honorable Judge Gonzalez.
Good evening. How is everybody?
Good evening, sir. All right. So basically, the panel's starting to fill up. I just pushed the live thing a little while ago. Okay. So basically, you want to introduce yourself. And by the way, while you're introducing yourself, do you have a website or anything that you want me to broadcast and share?
Unfortunately, no, not at the moment.
I don't have anything.
Yeah,
Okay.
not at the moment. No, I'm just here for the sake of hopefully sharing my opinion. So I'm a judge in the village of Elmsford in the state of New York right now as we speak. And while as a judge, I'm not permitted to share legal advice with anyone, I can obviously share my opinion.
Okay. Yeah, there's still people who are trickling in. So basically, I don't know. Is there anything else you want to tell us just to get it out of the way? So this way everybody has a pretty good idea, like about your, anything about your history you'd like to talk about?
Our court works in all sorts of cases: criminal, landlord, tenant, civil, pretty much anything that you can imagine. The courts in villages are very different than the city. We're expected to handle pretty much little bits of everything. So again, can't give specific legal advice, but can definitely give my opinion on a lot of different topics. And even outside of the law, my background is in science and political science. So I'm very interested in politics, current events. I've worked with the UN in the past on nuclear weapons. So pretty vast background. So I don't know what's coming up today, and be excited to talk about almost anything.
Tell me a little bit about that. What did you guys work on as far as nuclear weapons go?
Well, I worked with a NGO called the Lawyers Committee on Nuclear Policy, and what we were working on is the International Court of Justice made a determination at one point that the maintenance of nuclear weapons was actually illegal by the states, and we tried to enforce that. And unfortunately, it's not something that really was enforceable because there's no police behind that. So it's problematic. You can't convince the United States to, get rid of its nuclear weapon stockpiles just because the ICJ said it was the right thing to do, and when there's no one to oversee that. So it was problematic. It was difficult, but it was very interesting.
Now because that's really strange. How is it illegal to maintain nuclear weapons?
Well, the court's decision at that point was that the potential damage was so great that it's something that should not be held in anyone's possession, period. Now, the problem with that is the International Court of Justice really can only issue advisory opinions. So this was an advisory opinion. So basically, they don't have the right to set law in a sense that all of the other states must follow, or there would be some sort of punishment. While they do in some degree. So, for example, if you have a tyrant who commits genocide, the International Court of Justice or the International Criminal Court has the ability to prosecute that person. However, when it comes to political things, they're, for the most part, limited to advisory opinions, which at the end of the day, while, again, like I said, it's advice. It's the advice of a court. And I don't think that the United States is particularly fond of following that sort of advice. And not only that, we generally haven't even signed on to most of the treaties that would bind us to some of these courts. So it was difficult. It was very difficult. But again, like I said, very interesting work. Got to meet a lot of interesting people, work with some interesting people. In the past, I've worked with some politicians, local and state and national politicians as well on some campaigns. So background's a little bit varied. Hopefully some of the information and some of the work I've done can be helpful to somebody.
Well, because in my thinking, hold on one second. In my thinking, the only thing I don't understand is, what about the fact that these things have to actually be maintained and there's like no way around it? Just to make sure that there's like no nuclear waste or that there's no terrorism, getting to it, making dirty bombs, anything like that.
Got it. So when I'm saying maintenance, I don't mean maintenance in the sense of like you maintain your car. I mean just maintain them in existence.
At a distance.
No, in existence.
Oh,
So the court's advisory opinion was that they should not exist in anyone's possession, period. So their opinion was that, in essence, all of the states that possessed the weapons should begin dismantling them and removing them from their stockpiles, period. Now, that being said, it doesn't seem like it's a very realistic opinion, right? It doesn't seem like that's going to, in fact, come into play in reality.
okay. All right. I see. Okay. There was one person who had I had talked to the people who've gotten here thus far, because some people are like still trickling in, because there's like a couple of other people who, for whatever reason, decided to wait till right now to start going live, but whatever. We had a discussion about the logic of representing yourself in court. Now, it was my opinion, because obviously I'm not a legal professional, it was my opinion that representing yourself in court should be like kind of, how should I say, subjective compared to the stakes. So, for example, if you get like a traffic ticket, like or even like a parking ticket or something, and you want to present your side and say, listen, this is not right. I shouldn't have gotten this parking ticket, or I got this traffic ticket. I shouldn't have gotten this traffic ticket. In that case, it may be okay to represent yourself in court, because somebody in one of the panels, they held up a statistic and talked about the number of people who actually represent themselves in court. And they, some of them were successful. In fact, they were trying to make the case that the number of people representing themselves in court and actually like getting either lesser charges or getting found not guilty of whatever it was similar to the number of them who had professional legal help and were like supposedly they had a better rate of success by representing themselves. Now, when I talked to this person about that stat, I had a problem with that stat because I didn't think that the stat broke down whether or not what the stakes of the case. Like, it was as if they were treating the number of people representing themselves in traffic court as an equal to somebody representing themselves in a murder case. You know, and in my opinion, I felt it's not a good idea, despite the fact supposedly it's a right, but I felt that it wasn't a good idea because obviously you don't know court procedure. Obviously, you know, the star team of prosecutors who's against you are going to play games with you and eat you alive. Like, what do you think about that?
Well, I think you're touching upon something really important. I remember a kid's football game years ago that I was watching. It was a relative of mine, so I'm embarrassed to say, but it's true. The kid never played football before, gets the ball, and he's extremely excited. He thinks he's doing a great job, and everyone's cheering him on, but he's running to the opposite end zone, and he scores. But he doesn't realize what he's done because he doesn't know the rules. He has zero comprehension of what the game of football really is, and he's just excited at the fact that someone threw him a ball and he was able to run. And that's it. So I think it's very similar to court. There are people that think that it's a lot easier than it really is, but it'd be similar to me saying, hey, listen, my engine's not working so well. You know what? I don't really need to be a trained mechanic to get in there and fix my engine. You know, anyone can do it. It's true enough. There are some people that are not trained mechanics that can do the work, and some of them who can do a good enough job. That being said, it's a bit different when you're dealing with a physical thing, such as a computer, fixing a car, as opposed to something that's very fluid and that's constantly changing. So I think the issue, in my opinion, what I would present with law is that you have such a moving target. And for the most part, the people that want to represent themselves on larger charges, you look at, I remember the Colin Ferguson trial. Yeah. And that was a perfect example of someone representing themselves. I mean, if I remember correctly, at one point, he literally asks a witness, do you see the person who committed the crime on the train here now? And the witness says, yeah, you. and it was the most ridiculous back and forth period. And I think recently there was, the name is escaping me, there was a case out of state where a father allegedly killed his family and,
That was
however,
the
injured
one.
just a,
I was about to bring that up right now. It was the Ronnie O'Neill case. I
yes,
believe he stabbed his mother. No, I mean he stabbed his wife, and then he set the place on fire.
that's right. And then he actually was cross-examining his son in court. And again, it's an absolute mess. I think what people miss is that generally having an attorney is usually a great buffer because it lets you communicate with the prosecutors, communicate with everyone, and not actually be present for that. Because I would think that most prosecutors do their job and they do their job passionately, especially in certain fields like domestic violence, special victims like rape cases, things along those lines, child abuse cases. The prosecutors that do that type of work, I would think they do so because they're following a cause or a passion. And the last thing you want to do is you be the person who's, and this is just my opinion, what I would think you wouldn't want to do is you probably wouldn't want to be the person exposed to communicating with them, because the likelihood of them giving you a reasonable deal as opposed to an attorney who they don't necessarily have that emotional baggage with is probably much worse. As a matter of fact, I'm not sure that they'd even talk to you to begin with. So your chances of reaching some sort of negotiated plea might go out the window. Right now, I do agree, and regularly in my court, we do have people representing themselves on small claims matters. And I think what people fail to understand is that I think that small claims cases and other cases like traffic tickets, almost not as much. But small claims for certain, the judge has a tendency to take a lot of time and explain the proceedings to the parties, walk them through what they should be doing next. And that doesn't happen anywhere else. Everywhere else, the expectation is that if you're there, you know the rules and you're there to fight. It's like, you getting into a boxing ring and you're getting into a boxing ring with a professional fighter or with a kid that's been hitting a bag for a month or two. That's what I would equate to small claims. It's very light. It's gonna be very gentle, and whoever's in there as a ref or whoever's putting the fight together is probably going to help you guys out a lot in working out the way the fight should look and what you should be doing. But once you get thrown into a professional fight, there's no one helping you. There's no one walking you through anything. So I wouldn't represent myself on a matter, and if I'm charged in court with anything. I definitely, absolutely hire someone to do that for me.
Like, and see, here's the thing, and it's funny because like you brought up some interesting things that I'm going to try to incorporate into my language the next time one of these people tries to say this and I start arguing with them. But the fact that your attorney's a buffer between you and the judge or you and the jury. And I'm trying to think to myself, now mind you, they were bringing this whole idea of defending yourselves up as, well, first of all, we already know that this guy was a failure, this guy Ronnie O'Neill. So I think that right there should be proof positive that this is not a good idea. But the thing, like, cause see, in my opinion, considering the heinousness of the crime, he probably could have said, okay, I'm insane. And he probably could have been ruled insane and he might have gotten a lesser sentence. I mean, they're probably still going to give him life in jail, but they might have been able to push him through the mental health, whatever you want to call it, and the apparatus, and then say, you know what, this guy was clearly insane, and maybe further down the road, maybe he gets parole or something, for good behavior after considerable amounts of treatment. But this guy went up there, took on the system himself, and got basically found guilty. And the only thing, and from what I'm hearing, I don't think that this was a legal maneuver to spare himself from the death penalty, because as far as I know, the jurors came back and said, we're recommending life imprisonment without possibility of parole, but they stopped short of saying, we're going to give you a death penalty. So in my opinion, do you think maybe that's a legal maneuver that some people are using? Because you'd have to be insane to try to do this on this level And granted, it is your right to do it, but I don't know. What do you think about that?
Well, I think it's a tough call because you have to realize if you go through a trial, let's pretend that we go through a trial. Let's say it's me. I'm defending myself. I get through a trial. Now, if I remember correctly, the only options I really have are now to appeal or to make, if I lose, or to make a motion to set aside the verdict if it's a civil case. Now, those are really problematic issues. You're really facing an uphill battle at that point because you've already lost, right? It's like you've lost and you're aiming to see if you can correct something that went wrong already. But I think it's generally a lot better to what do they say? There's an old saying about avoidance rather than remedy, or cure rather than remedy. I think that's very true here. It's a lot easier to deal with a problem.
I think the saying is a preventive is better than a pound of cure or something.
I think you're getting there. I don't think either one of us has it right, but yeah, you're getting closer than me.
My mother says that
there you go. An ounce of prevention is better than a pound of cure. I think.
There you go. Yes.
Right. So I think it's true. I think that it's much easier to deal with issues before they become a problem, meaning before the case is closed, before you're found guilty. I think that's just a general opinion overall. I think it's just a better move. And unfortunately, many people don't understand that. In my days, I've seen some amazing attorneys do great work. I have seen some attorneys that weren't so amazing do some work. And that this is not as a judge, this is long before then. The attorneys I work with generally now are actually pretty fantastic. But I have seen and sat in on proceedings where there's just such an error of law that's blatant that as you're listening, it's not an error of law, it's an error of logic. And that doesn't help anyone, right? It actually hurts the situation. But then I've seen cases where the defense or the prosecution, one of them, is just so absolutely brilliant that you can tell that their performance is absolutely going to affect the outcome. So I don't know. I mean, I can understand there are many people that have a negative opinion of legal aid or non-private attorneys. And sometimes that's valid, sometimes that's not. I think I've witnessed myself sitting in a courtroom as a spectator some trials that some of the public defenders were just absolutely amazing. They were better than anyone else I've ever seen perform in a courtroom. And so I don't know. It's a tough call because it really depends on the attorney. It depends on the experience. It depends on so many things. I think that unless you're certain, because you have someone who has such a tremendous reputation, it's a tough call. As long as you don't have an attorney that's actually, in fact, doing damage to you, then I think it's probably the better call to err on the side of having a professional helping you.
Yeah, I agree with that. And one of Dave Sincere here says, it said no one is going to fight as hard for your freedom than you will as yourself. And that was actually something that one of the people who I was arguing with, they said that themselves. It's like, oh yeah, well, the defense attorney doesn't care, and he's still going home, and he doesn't care as much as you do, you know?
Well, let me put it to you this way. Let's just imagine this, right? I'm going to give you a scenario. Let's say I have cancer in my right lung, right?
Right.
I clearly care more than any doctor about my health and about surviving the surgery. Now, does that mean that I should be the person performing the surgery on myself because no one cares more than I do? Probably not. You know, I can see a Rambo move happening there and me putting some gunpowder into my wound to close it up. I'm probably not going to be as effective. So I do think that if I were charged with a crime or with anything, there is no one that knows my case better than I do, simply because I lived it, right? I was there. So what the best thing that I could do would probably be ensure that I have a good relationship with the person that's representing me so that I can have a proper back and forth and explain things and have someone working with me that actually understands what I'm saying. So I think something like that's very important, but just the idea of it not being more important to anyone else and it being most important to you, I'm not sure that that necessarily means that you're the best person to do that job, right? That by itself. So I understand, it makes sense. And you also have to look at, there is a reason why many, let's go back to the analogy of doctors, many doctors will not even perform surgery or procedures on their own family. It's because they're too emotionally invested. And once you're so emotionally invested, I think people have a tendency to be blinded and they don't necessarily make the best decisions. I have heard attorneys say many times that the most difficult client to have is a client who's innocent. And I sat down with a few guys and had this conversation. And the reason for it, I was told, was ultimately because the person who is innocent is very passionate about their innocence. And that makes it very difficult because then you have really only one way to go, which is if I can put one and one together to make two, if you're innocent, there's no way you're going through the procedures and accepting a plea deal, right? You're probably not going to want to plead guilty to anything. You're going to want to go to trial. You're going to want to fight this case. But the attorney might have a different perspective. Even though you're claiming you're innocent, the attorney may see that there are some negatives along the line that might actually hurt you. Or I would think that there are many people that think they're innocent of something, but then as you're listening to them say what they did, they actually, in fact, did commit the crime, but they don't think that it's a crime. And I don't know if that makes sense. I once...
Or, okay, they committed a crime, but they don't think they did anything wrong.
That's right. They don't think they did anything wrong, but then as you're listening to them, they're literally laying out, let's go back to law school. There's elements of a crime, right? There's elements of any charge. There's elements of anything. And let's say, for example, to have a breach of contract, there may be 4 different elements. If you meet those 4 elements, you have a breach of contract, right? That's the general rule that that's how any judge would decide. If you have 1 + 1 + 1 + 1, that equals 4. Now, if you're missing any of those ones, it no longer equals 4, which means there was no breach of contract. But the person telling their story, because they're so passionate about their story, they might think that they, in fact, did not breach that contract. And they didn't breach the contract because they have a very good reason why what happened happened. But as I'm listening to the story, it may be the most clear-cut thing that they actually, in fact, breached this contract. So they're passionately telling me the story, and I'm listening, and I'm supposed to pass judgment. But the truth is that they're every word that they're saying, they're making further admissions of elements of what they're charged with committing. So I think it's a very difficult call, but generally anything outside of small claims or anything outside of a parking ticket, and I would even argue with a parking ticket, I've hired attorneys to handle parking tickets for me. And I don't think that I would ever not do that.
No, yeah, I agree. And I will say this. One time I got a ticket for what the officer claimed was reckless endangerment. I went to court all ready to defend myself, and I just happened to be standing next to a traffic defense attorney, I guess you could call him. And I just went up to him and I was like, yeah, can I ask you a question? And I just told him what exactly happened. I told him the truth because I figured I might as well just tell him the whole truth. So this guy wasn't connected to me. He wasn't my attorney or anything. And sure enough, the guy was like, you know what? Don't worry about it. Just hang with me for a second. So he took me before the judge. And he was like, yeah, Your Honor, the officer said this, that, and the other, and I'd like to see, this is a minor infraction, blah, 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 and I'd like to get it knocked down. Sure enough, I walked out of there, $50 was my fine, and boom, I was out of there. And if I had tried to defend it myself, chances are it may not have been knocked down that much, but I will say the judge that day, he seemed to have been clearing cases really quickly. There was a woman who supposedly was laying on the tracks and trying to commit suicide on a train. And he looked at the case and he was like, "Oh my God, you're trying to commit suicide. $50, boom, you're out." And I was like, "What?" And sure enough, he cleared out the majority of the room. There were guys who had gotten caught for pissing in public after they got drunk, and he was just $50, $50, $50, you're out. And maybe I got a lesser charge. Maybe the attorney helped. Maybe he didn't. I'm not even sure at this point, but that was the situation.
So I see a question again from Dave Sincere that I do want to address before I touch upon what you just said.
Right. I pulled it up because I was going to ask it. Go ahead.
Perfect. The question is, does the legal system look at us as idiots when we hire someone to represent us? I don't want to speak for the legal system. I will speak for myself here. So I think it's an interesting question. And the truth is that it really depends on the situation. So, for example, if you are to go in front of a judge, any judge, and let's say you're filing a small claims case about, you had a visitor over to your house and that visitor damaged your TV, right? Let's say it's $1,000 TV. Now, when any judge would look at a situation in all likelihood and think, wow, this is overkill. You really don't need an attorney here. It's probably when it's something so simple that the reality is that it would be easier if I just talked to you and talked to the other person and figured things out myself. That type of thing. But those are really, to be honest, I think, again, in my opinion, I think those are really few and far between. Those are going to be very small situations. Like I personally remember I was in the Bronx just before the pandemic. I had my car parked overnight because I was working. And when I came out, my car was hit. And I figured out that I might have to sue the person who caused the damage because I don't know, I don't recall how, but I was able to get the information for the car that struck me. And that being said, it's one of those things where I had to think through, do I hire an attorney or do I just handle this myself? And I realized that the easiest thing to do here, because the facts are, I had a car that was parked, I wasn't driving, and my car was hit. That doesn't seem like it's a situation where it's going to be terribly complex and I'm going to have a hard time explaining to a judge what happened. Hey, Your Honor, my car was parked on the street. I walked out and there was another car on top of my car. I wasn't driving. I didn't have the key in the ignition. I was nowhere near my car. And the other guy looked like he was drunk and, he couldn't leave his vehicle until the police came. So that's a pretty straightforward scenario, right? I'm not fearful that I did anything wrong. I mean, I literally wasn't anywhere near the car. And the police report shows the fact that my car was parked. There was no one in my car. No one was injured. It's just an issue of the damage to my car. I think under those circumstances, if I were to have hired an attorney, maybe the judge might think it's overkill. Maybe the judge might think, it's not necessary. But the reality is that I think judges are so used to dealing with attorneys that it just makes things easier. The whole process gets moved more easily, I think. So to answer your question, Dave Sincere, it depends on what you're charged with. It depends on what you're looking at. And I think you have to make a very conscious decision because it also goes the other way, where if you're, in my opinion, if you're trying to defend yourself against something pretty serious, let's say something like a domestic violence charge, right? Let's talk about something like that. Let's say someone is alleging that you committed domestic violence against them. And you might be right in saying, I didn't do anything. And, I've heard of attorneys that have cases where there's evidence, for example, that the person wasn't even in the state when the alleged domestic violence incident occurred. Under those circumstances, even if you have proof that you weren't there or you didn't do it, the charge is so serious and the negotiations with the prosecutor are going to be so charged that I would think you would still want that buffer.
Okay, yeah, you're right, and I like that word buffer because that really helps put it into perspective for me in a nice, simple way. It's like I need somebody between me and the legal system because I can't handle this. You know. All right, so here's a nice question right here. This is a tough question. So I'm not going to ask you what your political leaning is. But Roscoe here says, what are your thoughts on the 2020 presidential election and the Supreme Court role in the issue from a legal standpoint?
Well, again, without giving any actual opinion, because I don't want to get into my personal opinion, I think that I think at the end of the day, many of the allegations might have been overstated. And unfortunately, I think that the beautiful thing about our system is that regardless of what your position may be, you have the opportunity to present that position and to have someone make a decision. And the courts have made their decisions. Many of the cases were dismissed very early on. But at the very least, I think the important part is that the people who had an issue had an opportunity to present those issues and to present any evidence that they wish supporting those issues. Now, it may be that some of us don't agree with the outcome. It may be that some of us do agree with the outcome. At the end of the day, I would take the position of just the system worked simply because it gave everybody a platform to make their arguments and to have a decision made. Now, I also, on a personal level, I think it's very difficult once issues like this have to be taken to court because it's terribly divisive for the country. Now, I also think that from a perspective of a jurist, a lot of times we may have a limited perspective on what's happening. And that's sometimes a bit problematic. And what people don't necessarily understand is that the jurist that's making a decision may be limited only to the information that's presented before them. They cannot take into account any other information, any outside information, only the evidence that either of the two parties present and that is admissible for the court to review. So that can affect the outcome because obviously let's pretend, let's look at a movie. Let's look at a really bad movie. Let's look at an old horror movie, the Texas Chainsaw Massacre, right? If you allow me to see the entire movie, I might be able to make an opinion and tell you that was a great or a terrible horror movie. But if all I see, I'm sure that at some point in that movie, there was a couple holding hands walking down the street or sitting in a car having a conversation. And all I see is a snippet of that piece of information, just that bit of a scene. And you ask me what my opinion on the film is, I might miss the entirety of the idea of what Texas Chainsaw Massacre was about. I might think this was a love story. I might think, oh, it's a cute story, a young couple sitting in a car having a conversation. I'm sure they probably going on their first date, etc. I might come to some conclusions that wouldn't, in fact, be the same had I seen the entirety of the film. It's the same with evidence. I think that what people don't understand is it's ultimately the attorney's job to present that evidence. And if they can't or if they don't, then I believe that the court can only make a decision based on what's been presented to them.
Okay. Nobody's asked it yet because I guess there's nobody passionate about it just yet who's asked. But I'll say it like this. Obviously, the COVID situation and everything that was surrounding it was basically, I would say, unprecedented. I don't think we've ever seen something like that during a presidential election before. A lot of people claim that the Democrats used it as a ruse or as an angle to help get Trump out of there and change the election system to vote by mail so that they could make sure that they had dead people vote and blah blah blah. Those are the allegations that you hear thrown around the most. And now, obviously, you see these people trying and desperately to defend the actions of the people who came there on January 6th to riot at the Capitol. Of course, they're going to just say it was a protest, and I said it was a riot. But we both saw what we saw on the news, whether we saw the whole thing or not.
Well, that's right. I also think that people, there's a reason why they say the worst type of evidence is eyewitness evidence. It's because people see what they want to see.
Exactly.
If you're looking at the events in January, you might, depending on your perspective, you see a peaceful, protest. Depending on your position, you might see violent rioting. And truth be told, I'm not sure that really matters in the end, because I think, again, once you're making an allegation, if you're making an allegation that this is X, right, this is a violent riot, then in order to actually have a court make a decision on that position, you would have to present evidence of that. I can't do that in a vacuum. So the tough part, I think, is that there are people taking political positions. There's so many people taking, leftist, the rightist approach. But truth be told is that the same exact fact pattern or the same exact event could easily be interpreted differently by different people based on their own perspectives and their own predispositions. I think that's a huge problem in politics for us, right? I think it's the same reason, for example, I was of the opinion, while I was not necessarily a Trump fan personally, I can definitely agree with some of the presentations that people would argue that some of his ideas were actually quite good, and that some of what he put into place was actually in fact effective. I do think that, from, again, just my own personal opinion, I think that there was a presentation problem with President Trump, and I think that I said this before, and I'll say it again. If I were to present a steak dinner to you, and I present it on a beautiful plate with wonderful, accoutrement and on a wonderful table, it's going to be very different than if I took the steak and I just put it on a trash can lid and fed it to you. It's the same exact steak, meaning it might be the same exact information. It just depends how it's being presented. And I think presentation also matters with regards to events like these January events, where, for example, if the presentation or the news story is by Fox as opposed to CNN, the presentation might be quite different, and it feeds into your own prior prejudices of the situation. I think part of the problem is that we as people do not leave our own boxes and look at things from an outside perspective. And instead, we really consume media that feeds our own opinions and our own prior prejudices. And unfortunately, that's why we're so divided politically, right? Because the truth be told was that the events happened in January, the election happened. There are facts, there are things that actually occurred that we can all agree upon. However, we have a tendency to look at things from our skewed perspective and continue to argue our point. And I don't think that's changed, unfortunately. And as a trier of fact, as I'm sitting on a bench and as I'm listening to people make a presentation, my job really is to cut through all of the prejudice, because truth be told, you're still human. You're a human being, right? And regardless of that, let's say, for example, I know for a fact there are people that are judges that may have had domestic violence in their past, child abuse in their past, anything along those lines. So you better believe that if you present the case in front of them, there is going to be some sort of emotional issue for them in hearing this case, right? They may be charged in one direction already. Most, if not almost all, really, however, are trying to remove their personal opinion and their personal views, and the better people, the better prosecutors, the better judges, the better defense attorneys, the better doctors are the people that remove themselves emotionally from a situation. And I think I want to go back to one of the prior questions. Just because you're emotionally invested, and you're maybe the most emotionally invested in the situation, again, doesn't necessarily make you better to handle a situation. Sometimes you actually need the outside perspective. Sometimes you need that middle road, the person who can see both sides and then speak to you as to what the dangers and the pitfalls are from the other side, right? So I think I think that's terribly important.
No, I absolutely agree. We may end up addressing another question similar to that, but the next question somebody asked, your background as a defense attorney, have you ever had to question your own ethics when defending someone who was clearly guilty of breaking the law? This is kind of like Richard Gere on Primal Fear.
Yeah. So I think that I've spoken to and I've known a lot of defense attorneys and I've known a lot of prosecutors. And I think at the end of the day, people really try to just do their job as best as they can. And unfortunately, the issue of litigation is it's very much a game. It really literally is. It's a back and forth. You have players, and there are people that are trying to one up the other. There are also people, there's the old saying back from Jonestown, the sipping the Kool-Aid. There are some people that really buy into what they do. And they get very, like I said before, they get very passionate about what they do. And they begin to get blinders, where these blinders, affect their ability to see the outside. I think that, interestingly enough, if you come from a defense perspective, that you're equally as potentially guilty of that as if you come from a prosecutorial background, right? It's easy to just fall into the trap of seeing only what you're looking for. If you're a defense attorney, you're always arguing your client's not guilty, right? Sometimes I'm sure that the truth is that you may not believe that your client is innocent, but you're making the argument anyway, right? Because, and I'm sure you probably end up as a defense attorney coming up with some very creative ways sometimes to figure that out. But once the role shifts, I think that, people have to look at things differently. If that same individual then becomes a prosecutor, now they have to play that role as best as they can. I do think that for the most part, most of the people that play the role of prosecutor, of defense attorney, of judge are not emotionally invested at all. They're taking a step back and they're just simply trying to do their job to the best of their abilities. I think, however, the question is very valid. If a person becomes a judge and has a background in defense as opposed to prosecution, it may be that the person who has a background in defense might be a little more sympathetic to people. And it may be that they're not. It may be that they make the decision to say, screw this. I cannot deal with these people anymore. There's always an excuse. I now want to be the most difficult judge that I can be. Or the other way around. You've gotten used to dealing with people and you understand people's difficulties. And when you take the bench, you take it from a perspective of saying, you know what, not everyone that's accused of a crime is a bad person. It may be that there was a bad situation, or it may be that they're in fact innocent, right? Or if you're dealing with a small claims matter, if you're dealing with something else of the sort, it may be that you look at it from a more open perspective. But I think the question is a very valid question. It's also very easy to be skewed by your background. And it's easy to do that in any profession, in any career, in anything you do, right? Your background has a tendency to color the way you look at the world. So I think the question is pretty simple. I think with regards to ethics and defending people, I think at the end of the day, most attorneys will tell you that, or the attorneys that I've spoken to all take the same position, that everyone is entitled to have a defense. And I think a lot of the logic is you do have to realize that the system doesn't necessarily see things as equal. And what I mean by that is there are two different people that can be charged with the same exact crime and both be guilty. Let's assume they're both guilty, right? If I'm in the role of in a room with a defense attorney and I'm trying to hear and I'm listening in, I'm sure that defense attorney's main goal is to at least keep the individual somewhere in the median ground with regards to what the disposition would be, meaning what the sentence would be if that person is found guilty or pleads guilty, right? What you don't want is you don't want a person charged with something that's very low end, but getting a very stiff sentence. And unfortunately, that actually does happen. You know, you do hear of cases where an individual is charged with something and other people get 3 years on average for this case, and this one person gets 12. And, you know, maybe from my perspective, as I'm listening in, my question becomes, well, wow, how did that happen? You know, how did that person? And it didn't matter at that point. Even if you told me the person was guilty of the crime that they committed, I think my bigger concern would be more so, was the outcome fair? Right? So I think many defense attorneys don't necessarily go into it thinking they're going to remove people that are guilty of crimes from serving jail time. And I think that's a little bit of a misconception. I think defense attorneys do try their best, just like prosecutors do, just like judges do. They try their best to win, just like anyone does in any game. But I do think while many people think the system is flawed, I think the system works well enough where the judge that's hearing the case usually gets a pretty good idea of what the facts are, and the jury, more importantly, generally gets presented a pretty fair presentation of the events. Now, unfortunately, if any one of the attorneys is lacking significantly, that could affect the outcome, because like I said before, if the jury only sees one side of the story, it might be easier for them to side with that side, right? Because they didn't hear anything else that's helpful on the other end. But I think that just on this topic, I do remember a conversation with a defense attorney a very long time ago. And it was a very interesting conversation. That attorney was mid-trial on a very serious case, on a murder case. And the defendant really had no idea that he was losing miserably, and that all of the evidence was pointing to him getting a conviction. And if he were convicted, the judge that the case was in front of was known as what's called a hanging judge.
Yeah,
which means you're going to get hurt, right? Yep. You're in front of a judge who's going to beat you up as best as he can if you're convicted. Now, that being said, the person who was facing the charges thought they were doing a great job. He thought the defense attorney was doing magnificent, and that the likelihood of him getting off was really, really high. And that's really unfortunate, but that scares me. And that's another reason why I would, going back to your question with regards to defending yourself, situations like that really, really concern me, with the idea of having someone represent themselves on something serious like this. Because if this individual had represented himself, he would have thought things were going fantastic. He would have thought he's going to get away with this. And in the end, it was literally he walked himself into a life sentence.
Wow, Jesus!
But it's very different. I think the biggest misconception is that the rules aren't actually logical, right? So, for example, if you think, let's say, for example, you might think, hey, there's no way I robbed that person. All I did was, I had a conversation with them, and then that person had something on their pocket, and I decided to pull it out and take it and run away. And you're facing now a very serious charge, and you're looking at a possible robbery. But if you actually explain the facts just that way, even though what you did might sound to you more like you pickpocketed the person or something to that effect, it might rise to the level of being something so serious where it actually would be considered a robbery and then would mandate state jail time. So I think the biggest issue really is that I don't think people generally understand the definitions of what things are within the legal system. And that creates a strong deficit, because you're walking into it and you're assuming what something means. For example, murder. There's the idea of, think back to law school. Most of us has probably read about the idea of felony murder, right? Mm-hmm. And truth be told, a felony murder is the idea where if I'm committing a felony with you and let's say we go into a store with the idea of robbing the store. We pick up guns. We purposely say these are fake guns, There's no ammo in the guns, right? They're old guns as well. They're replica weapons. There's no way that either of these weapons is going to shoot someone. Right? You're not killing anyone with it unless you beat them to death, and that's probably going to take a very long time. But you walk into a place, you start your robbery, and as you're doing that robbery, the person has a heart attack and dies. You might think you might be charged with murder after something like that, right? Under the felony murder rule. And you might think, what? That doesn't even make sense. There's no way I killed this person. But the law might interpret it differently.
Here's a question. Would that be like murder or aggravated like manslaughter?
Well, I think it would depend where you are. State by state, the law would be different. The bigger concern is that you could fear, under those circumstances, you didn't, in fact, factually, you didn't do anything. You didn't touch this person. You didn't shoot this person. You didn't hit this person. The person happened to have a heart attack during the commission of a separate crime. But that being said, the fact to most people, to most rational, normal, average thinking people, the fact that someone could even be charged with any level of murder, manslaughter, so anything, is probably not real to them. It doesn't make sense, right? Because they, in fact, didn't do that crime. Here's another scenario. There's a theory called constructive possession, right? And I have had this conversation over the last 15 years with attorneys back and forth. And the idea is, for example, there are states where you might be driving in your car, right? And you have nothing illegal in your car, but you let your buddy in your car and your buddy has a little bit of heroin in his pocket, small amount, nothing that's visible to you, right? You get pulled over by the police, you both get searched, the heroin is found in your friend's pocket, in his possession. The idea that you, as the driver of the car, who never touched the drugs, who never knew that they existed, never knew they were there, never had any reason to believe that your buddy ever used, the idea that you could be charged with possession of those drugs is usually pretty foreign to most people. But the law in many states does allow you to be charged with possession of those drugs. So if you're walking into it saying, I'm going to defend myself, there's no way that this even makes sense, right? I'm just sitting in my car and my buddy happens to have a little bit of weed or some heroin or whatever it may be in his pocket. And how could I even be assumed to have known that it was there? But, you're missing the fact that many states have something called, again, constructive possession. And then there's also a presumption situation under there where many states will say that if you're the driver and the owner of a car, you're presumed to know everything that's in your car. So right. What that means is forget your friend, you pick up a hitchhiker. You've never met this person in your entire life. And that hitchhiker has a duffel bag with a little bit of weed in it. Guess what? In some states, you're now guilty of possession of that weed.
Is that even constitutional, though? Because it seems to me that violates, like, individual rights.
Well, how so?
Well, okay, for the exact same reasons you pick up. It's like if I have someone else who has their own private property and they're responsible for their own private property, I can't scan them getting into the car. How would I know? Like, I couldn't know what they have on them. And if I myself didn't commit a crime, I shouldn't be held liable. Like, for instance, if they're a heroin addict and their blood is filled with heroin, should I be locked up as, like, transporting a heroin addict? That doesn't even make sense.
Well, that's really different, of course, because now it's not a possession. It's the person has it in their bloodstream. Obviously, you can't physically possess that. And
what if it's like what we saw that movie? What was that movie? Maria Full of Grace, and her stomach stuffed with fucking cocaine bags or something, or what was it? She'd swallowed cocaine bags. Yeah. What about that? That possession.
So now let's say, I guess that's an interesting idea. You have a mule sitting beside you, right? Yes. And that mule has an abdomen full of cocaine. Now, it could be, technically, in many states, the law, I mean, again, just my opinion, and that's what I'm saying. I don't think I've ever heard of a situation like this happening. I'm sure it has. I'm sure, some people can speak about it more intelligently than me because they've read about a situation like this, but I don't see the difference from it being outside or inside. And the issue would be, it's similar to, I've heard of situations where, let's say, for example, you're a shop owner, someone walks into your shop and wants to sell you a TV for 20 bucks. And, you buy the TV and you sell the TV, right? And police come in at once someday and decide that, to arrest you, and they say you're guilty of possession of stolen property. Now, the idea here is that you could theoretically make that out because you should have known when you purchased the TV for $20 that that TV wasn't worth $20. So there's something fishy. And the fact that someone walked into your store, maybe it was boxless, many other factors, but you could be charged with something that you didn't knowingly do under a presumption that you should have known. And the issue usually is, let's go back to law school again, it becomes reasonableness, right? If you reasonably should have known something, it's pretty fair that someone will say you should have known, and they'll charge you with as if you should have known. So with this mule situation, I think it's going to be factually different depending on whether is the person sweating profusely, is their abdomen large, or is it completely not visible? And if it's in their body. Now, the issue really with that, though, it's a bit different because how do we let's say you're stopped and you're physically searched, right? Both of you by the police. How are they finding this thing that's in her abdomen? Right? That's not going to happen. It's not going to be visible on the outside. And for the police to get the ability to search, I think that would be a higher standard. So they would have to go through other steps before they get there, I would assume. And I think that it wouldn't necessarily be met by just what occurs at a traffic stop. Now, unless that person is, again, like I said, sweating profusely and something's coming out of their body, that might be different. But if there's no signs that there's anything within the person, I think it'd be very difficult to claim that the person who was a driver knew or should have known of something that was within the person's body.
Right. So and I would guess the prosecutor that would be assigned might just skip him, maybe not charge him with anything, I would guess.
I would probably guess something similar too. I would think that a lot of times, I think prosecutors, they know their burden. They know what they have to prove in order to get someone found guilty of a case. And I think that if they're not able to do that, meaning if they're not able to meet their burden, many of them usually are ethical and intelligent enough to do the right thing with the case. Now, that's not to say that happens with everyone. I think, again, everyone is different. Some people get into this situation or their jobs because they're extremely passionate, for example, about.
It's funny, your voice changed as soon as that one from the left side fell out. Your entire voice changed. That's kind of strange.
Sorry about that. Let me see.
Those are the Apple ones?
Yeah, those are the Apple ones. They're not great.
I don't like the dual boom ones. I don't like them. Let me speed up just a couple of these things. One of these people, because there's somebody else who had a super chat. One of these people says, "Oh, I have an attorney." This is Dave Sincere. "I have an attorney I hire for traffic ticket here in Atlanta. He's very good. Once got a $792 speeding ticket. Paid him $350. He got the fine reduced to $400. Paid him, and the fine was still out of $750. Yeah, basically." Okay, somebody else says, "I'm ready for the debate." Yeah, that's coming. Somebody else said, "I'm late." Salute to everyone in the chat. Now, I had a question here from a super chat. This is Dave Sincere again. He says, "In districts other than your own, can the relationship between a lawyer and a judge make a difference in the verdict of cases?" I'm just going to make it so if you try to make your answers a little shorter, so this way you don't burn yourself out. Yeah, so this way you don't burn yourself out because I'm bringing up the main event soon. So go ahead.
You got it. No problem. So I think at the end of the day, the relationship between the attorney and the judge should never affect the outcome. The outcome should always be what it would be otherwise. If most judges, if they have a relationship with an attorney, will recuse themselves, meaning they will step back. Otherwise, generally, most places will require the attorney and the judge to disclose that relationship to the people involved. And the people can usually take a position and say, for example, let's say I'm a judge on a case and I really dislike your attorney, right? I had an issue with your attorney. As a matter of fact, your attorney has sued me in the past and I sued him. I have to disclose that information to you, and then you would have to make a judgment call as to whether you want to keep your attorney or whether you want to keep me as a judge. Because you might say, Judge, you cannot hear this case. It's hard for you to make an impartial decision. Right. And at that point, I would have to step back.
Yeah, that makes perfect sense, because see, it's my personal belief that just about everybody knows each other, and that if I happen to get the right attorney, that him and the judge are golfing buddies, and it's going to go easier on me. That's just my, belief. That's like something you see in television and movies, But that's just what they make it out to be, whether that's true or not. But yes, as far as recusing yourself, yeah, that makes all the sense in the world.
Of course. Now, just on that same note, there are some judges, maybe the relationship isn't a friendship relationship, but maybe the relationship is an attorney has appeared in front of that judge many times before and done an amazing job. So the judge might think this attorney is better than most. That helps you in a sense, because I might not look in as deeply when that attorney is making an argument, because my prior experience tells me this attorney is right. This attorney knows his stuff. This attorney knows what they're doing. So I may actually not push so hard against that attorney as maybe if the attorney that's appearing in front of me has a history, for example, of making mistakes, of not showing up on time for things. These are all things where if for example, if I'm making decisions on your case, they may in the end affect the outcome, but it has nothing to do with a personal relationship with the attorney. It's more so my prior history with the attorney, right? So that may dictate me being a little bit more difficult or a little bit more relaxed with that particular attorney.
Okay, so as far as we started out by talking about self-representation. I know a couple of other people had asked a couple of questions that had to do with family court, but I'm going to wait till later to get to that. And somebody also had a question about your opinions about people who might want to study law as a profession. But the person I'm going to bring up right now had his own, he was giving out some advice, and he's the one who quoted me that statistic. So I'm going to let him up right now. And I'm going to let him pose his questions directly to you. Okay, so his name is Ramil, and go ahead, Ramil.
Yeah, what's going on, Big Truck? I just got here. I didn't get to hear the beginning, so
right. Okay. No, well, I started out with your. Go ahead. You ask your questions. Go ahead.
So how you doing? So I was just curious as to what's your opinion on self-representation or pro se litigants?
Okay, so I think we did touch on this before. I'm sorry that you weren't here, but I'll try to get through it as quickly as I'll give you my definite opinion. And it depends. That's my opinion. It really depends on what it is that you're facing and what you're looking at. So, for example, if it's a small claims case, it might be more reasonable and it might make more sense for a person to represent themselves. If it's a murder charge, it probably doesn't make sense for a person to represent themselves in almost any situation. And I look at the recent O'Neill situation, the Colin Ferguson case, which I personally followed pretty intently. And it's the defense. There's never been a situation on criminal cases where I've heard of, not even seen myself personally, where I've heard of defendant doing a very good job and getting and securing a really good outcome. Now, generally, most judges, most prosecutors in those situations, they will try to do their job to the letter of the law. So there's some sort of a buffer there, right? Because you have in criminal cases, You have a prosecutor who's trying to do the best job that they can do. You have a judge who's trying to do the same. And in a sense, that protects the person who would want to defend themselves, because neither of them want to do any ethical violations, or neither of them want to make any flaws or errors in the record. But that being said, I think you're at such a disadvantage that it doesn't make sense. And that word buffer is key. Generally, even if it's not in a courtroom, the idea of having someone as a go-between between you and the prosecutor is usually a very, very good thing. Because especially, let's say, with a murder case, with a domestic violence case, with many types of cases that are a little bit more emotionally charged, you generally get people on the prosecutorial end of things that are really passionate about what they do and will go after you as best as they possibly can. So it's problematic. So I think it depends is the short answer, right? And it depends. It's a whole spectrum. It could be low end, a traffic ticket. Even myself personally with traffic tickets, I generally have not appeared myself. I've usually considered at the very least hiring someone.
Well, I asked that because I had just myself. I was in a situation where I got in a situation for marijuana possession, and the police decided to lie on the report and said I had a marijuana on me, when actually my passenger had it on me. And so I represented myself, and I was able to get that case thrown out. Also because of the fog line violation. That's really not probable cause to be pulled over, but they use it anyway. So I got the case thrown out. So I decided to sue the prosecutors. So let me ask you another question. Do you think the prosecutors should be able to be sued, or should they be able to have absolute immunity?
Well, I think that there's a lot of things that could change within the system. And let's talk about police. I don't want to talk about prosecutors specifically, but you can, by analogy, assume what my opinion and what my suggestion would be. I think at the end of the day, whenever you have immunity on something, it creates a situation which is unbalanced and unfair, right? Because you're walking into a situation where you could make a mistake. You could not only make a mistake, you could maliciously go after someone, and you're still protected for the most part under the law. I think that you're in a situation where you have an increase in police brutality and police violence, and I don't even want to get into racial issues, right? Let's just talk about police brutality and excessive force in general, right? I think that things would be very different if the police officers that are committing these acts of violence were somehow held responsible for them individually, right? I think it would change things very greatly. And unfortunately, that's not one of the changes that I don't believe any real system at this point is considering making. But I think those changes would reflect on everyone in the system. I think greater responsibility and less protection will make people more considerate and more apt to really looking at the facts, and more apt to, for example, if I'm a police officer and I'm approaching you, I might be less inclined to think about violence if I know for a fact that not only would I lose my job, but I might get sued. I might lose my pension. I might lose my home. I might lose, other things. But as it stands right now, if I'm an officer and I decide, well, it's a terrible example. I was going to say, if I decide to kneel on someone's neck for 8 minutes, unless there's a massive outcry, the truth is that in many situations, there may not be the same repercussions than what we recently saw going on in court. Because if I remember correctly, there was a relatively well-known comedian who came out, I think it was a Saturday Night Live guy, who mentioned that he had a similar situation where someone kneeled on his neck for a significant period of time during a traffic stop, or during a stop of some kind. I don't think he was driving at all. I think he was just jogging, if I remember correctly. Now, the problem is, if I'm an officer and I have no limitations and I know there's going to be no harm to me, why wouldn't I act as aggressively as I can? Because you have to realize many times, I think, from my perspective, I assume that everyone is a good person trying to do their job. Police officers, prosecutors, defense attorneys, judges, everyone. I assume everyone goes into what they're doing thinking that they want to do good for people. But that being said, there are people that don't do that and don't go into these professions.
That's what I'm saying. So should they be held accountable? I mean, I know everybody always like to skirt the issue of the prosecutors. Or should the prosecutors, when they maliciously prosecute and when they step outside their boundaries and violate civil rights, should they be held? Because that's how I got a lawsuit on right now. I have a lawsuit against a police officer, have a lawsuit against the prosecutor and the prosecutor's officer. And right now, in the federal district that it's in, they're trying to determine if they have immunity or not. They're deciding it right now. So I don't know. We're waiting for the decision to come back. So you as a judge, should the prosecutors, if they maliciously prosecute, like if they blatantly ignore evidence, blatantly do something, should like for Bill Cosby right now, the prosecutors blatantly, literally violated what they said they was going to do. They violated the contract. Should prosecutors be punished, or should they have to answer the claim for civil rights claims if they maliciously prosecute?
Well, I think you're asking a different question that you're asking, right? I think your question is a little bit different than what you're saying. So, because what you're saying is, should they be held accountable? And you're saying that you have a malicious prosecution case in federal court. So obviously what you're saying is there's something that exists that if a prosecutor commits malicious prosecution, there's a way for you to then make a claim against that person, right? So it exists. I think what you're really asking though is more so, should they have as much protection as they do, right? Because you've made the claim, and the system exists, right? Now the truth is, I think I'm agreeing with you. I think in many circumstances there are too many protections afforded, and when you have that level of protection, it's very easy to make mistakes. 2, not hold yourself accountable to a higher standard. And 3, sometimes if you actually, in fact, maliciously want to go after someone, it becomes very easy to do that, right? Because you might think that there's going to be no issue, there's going to be no harm to you on the end. So why not, right? Especially, for example, let's think of a movie, or let's think of fiction, right? Not reality. If I'm involved in a case and I'm a police officer, I'm a detective, I'm a prosecutor, I'm anyone, and I know, let's say I walk into it knowing this guy did that. I have a feeling, I have a gut feeling. Truth be told, is that gut feeling is absolutely worthless, right? This whole thing that you see on television with, I go with my gut, or, I had a hunch, all of that is absolutely worthless. Right. And unfortunately, it happens a lot where people go with that. People use that opinion. People use that skewed perspective that they have, and it affects everything that they do moving forward. Now, should they be punished for that? I think it depends on the situation. If the violation is so egregious, where, for example, it is that you kneel on the back of someone's neck for 8 minutes and 46 seconds, then maybe that does merit criminal prosecution and a conviction, and maybe that's what should happen more often. But if the situation is, I'm a scared police officer, which I've heard before, I've heard news stories about something similar to this. I'm a scared police officer in a dark building, and I hear a loud noise. I think I'm being attacked, and I shoot at that whatever I think is attacking me. And that bullet ricochets 2-3 times, striking someone else. And now that person files a claim against me. Should I be held to the same standard as that other officer who clearly intended to kneel on someone's neck for 8 minutes and 46 seconds? Probably not. Right? I think the standard it can't be a cutoff where it's just a straight line. There has to be different levels of accountability. And I think part of the problem with the system is that we go from black and white. We don't do really well with gray. So it may be that, for example, you have some level of responsibility, but not all. But the system really deals with yes or no, right? Are you responsible? Are you not? That's it. Immunity, no immunity. There really should be more gray, but the gray is really hard to enforce. And the fear for a lot of people is that we have a system that may not be necessarily fair to a lot of people, and we're trying to fix it. It's trying to be fixed. There are lots of people working on that. But in a sense, there's a reason why there's black and white in the system, yes or no. The reason is they think it might be more fair, right? And now in practice, it may be that that's not true, right? It may be that that's not the case, but that is what we are trying to do. That is what many people within the system are trying to do, create greater accountability for prosecutors, for police officers. That was part of the entire bail reform, as a matter of fact. I'm not sure if you were aware, but for example, I heard of New York having a bail reform, I think in January. And the idea was that many of the cases that a judge could set bail on before it's not possible any longer for that judge to set bail. Now, the reason for it for a lot of people was that there were so many people of color that were being held during their trial before they were convicted simply because they couldn't make bail, to the point where certain prisons that held people pre-trial, like Rikers Island, etc., the vast majority of people within that prison were people of color. And when I say the vast, we're looking at, in some instances, 80 to 90%, right? And many of them, it's not because, again, if you're here in one of these prisons, it's not because you're convicted of a crime, it's because you're charged with a crime. And if you're charged with a crime, there should be a presumption of innocence, right? So why is a person, for example, I don't know if you read these stories, but there were stories of Bronx County where people would wait 5 to 6 years for a trial on a misdemeanor case because the system was so bogged down. Now, what if it's me? Let's say, for example, I'm charged with a misdemeanor and I can't make bail. I'm inside, right? And let's say it's 8 months, it's 10 months to me waiting for this trial.
Is that the defendant's fault for not asking for speedy trial?
No, actually. Because that's a great question. And obviously each situation is different. Problem is that, as you know, or as many of you know, I think that the system counts things very differently for speedy trial. Not necessarily every day that a person is in fact counted towards speedy trial, right? But let me just go back to my analogy. Let's say I'm in for 8 to 10 months. And I'm innocent. I'm actually innocent. I know I'm innocent. I didn't do what I'm charged, this misdemeanor that I'm charged with, but I'm poor. I can't make bail. So guess what happens? If bail is set on me, I'm sitting there for those 8, 10 months. And now I'm being told that the likelihood of me getting to a trial is 3, 4, 5 years away. So guess what my decision might be? My decision all of a sudden might be a misdemeanor. The maximum sentence I can get is a year, and I'd be out in 8 to 10 months. So do I plead guilty now and go home, or do I sit here and wait to be found innocent 4 years later? It doesn't make sense. And lots of people tried to change bail as a result of that, and they succeeded, right? Bail was changed, and it definitely had an impact on the system, the way things work, good or bad, right? Because there's lots of people that now are claiming that there's some strong negatives about bail reform. But on the same note, it's definitely coming from a perspective of trying to make things more fair. So there is changes, there will be changes. This issue that you're presenting is an issue that a lot of people are talking about. So I'm assuming that at some point in the future, there will be some changes, but there haven't been any changes yet. So unfortunately, you're stuck with whatever your attorney is telling you to do, right? And I can't give you any advice as to anything differently. But other than there are people that are trying to change things, and they're succeeding, because bail reform was a proof of that, right? That came solely as a result of people thinking that the system was treating minorities charged with crimes prior to their convictions, very unfairly. And they were right. The numbers don't lie. When you have 85% of people in Rikers Island and other facilities awaiting trial that are people of color, brown and black, that's a little bit of a problem.
Let me ask a question real quick. Ramil, in your state, is marijuana legalized for medicinal and recreational?
No.
It's not. Okay. And your person who's in the car with you had it, but not you.
Yes.
Okay. So did the other person, because usually, like, as far as I've seen, it's like the cops say, okay, one of you is going down for this. So who's going to fess up? Did your friend say, this is only mine? Ramil had nothing to do with it, or what?
No, the friend said, it's in my bag.
It was in your bag, but
No. The friend says it's in my. The friend said it's in my bag. That's what the friend said because it was in her bag. That's what the friend said. It's in my bag.
so your friend snitched on you.
No, she said to herself. She said it's in
No,
my bag.
no, yeah, I think he's saying the person confessed.
Yeah,
So did
exactly.
the person make it clear that this had nothing to do with you? It was just that this person's a weed smoker?
No, she just says in my bag.
Well, I think that's helpful to you because usually if a person admits responsibility, I think it becomes harder for the prosecutor to then say, for example, let's say, okay, think about it this way. You go to a trial, right? And that person then testifies, listen, it was mine. He never knew that it was in the car. He never knew that I had it. You know, I bought it from such and such a person. It was in this pocket. I think it becomes much harder for a prosecutor to then say, you know, Ramil is responsible, right? It's much harder. So
But they did it anyway. That's what they tried to
of course,
do.
I'm sure. I don't doubt that. I think what I'm saying though is that the situation you might have been able to defend yourself better simply because the prosecutor has this limitation. But if the person didn't speak, didn't say anything, you know, I don't think things would have been as easy for you or as smooth for you. Not that they were smooth or easy, because obviously going through that level of prosecution, I'm sure it's not comfortable. It's not good, right? No one wants to go through that. But I'm just making the point that if the person didn't confess and didn't say anything, I think your situation would have been much more complicated.
Well, they also violated. The police had this thing where they like to pull people over because when they touch the little sideline, the little fog line. But most states say you can't do that, but they steady do it anyway. Like the state I was in had the case law say you can't pull people. That's the other issue I had. That's why they pulled me over initially. They said I touched the fog line. So that was the other issue I brought up. So it was just too many things.
You said touch the fog line?
Yes, on the express, you know, the white line on the side of on the side of the lane. Each side is called the fog line. If you touch that, sometimes the police will use it as a reason to pull you over.
Oh, I drive over those with impunity.
You will.
Go
I'm
ahead.
just saying.
Yeah, go ahead.
But if they do pull you over for that, usually the state say they can't do that. But because so many people just plea out, they usually use it as probable cause on the reports. But let me stop giving y'all a game.
Well, okay. I do want to touch upon the question from Roscoe. What's the opinion of judges and prosecutors using politically charged situations to make their careers via biased decisions? Well, again, I walk into it, maybe I'm naive. I don't know. I walk into it with the assumption that everyone in the system, under most circumstances, is trying to do their job to the best of their ability. Now, do cameras change things? I think, unfortunately, they do, right? I do think that having cameras present, having massive media coverage does change things. But the reality is that for judges, for example, I don't think that people are aware very much, probably because it's rather, you know, it's not necessarily public information. But for example, me having a media case in front of me, if I'm a judge on a case, that doesn't necessarily mean my career gets made and now, you know, I get moved up to what? I mean, the best I can do would be maybe a head judge of a courthouse. And that usually for most judges doesn't really come with a pay raise or anything. It usually just means more responsibility. So I've heard of many judges being offered those positions and turning them down because it doesn't make sense. It's human nature. If you're, let's say I'm 65, let's say I'm 40 years old, right? And I get offered a position like that, maybe my life situation is different than if I'm 75 years old. Maybe if I'm 75 years old, I don't want that responsibility and I pull away. Now, If I'm 35, maybe I take the responsibility and then I see what happens with the next position or the possibility of something else. But there is really nothing much more than, let's say, if I become a head judge of a particular courthouse, maybe the next role would be the head judge of an area. But again, it's one of those things where there's no pay raise for me. There's just more responsibility. And many people don't necessarily want that. I mean, unfortunately, I think from what I've heard, there are many judges that have heard cases that are significant media cases, and they're actually not excited about it. I mean, they would prefer to not have the media coverage and just deal with it internally. Because the problem becomes, once you have media coverage, let's talk logic here. Let's talk regular, everyday stuff, right? Let's say I get to make a decision on a case. Let's talk about a domestic violence case, right? Something really simple. And it's happened before where a man abuses a woman, he's charged, he goes to court, and he's released, and he then goes and re-abuses the woman or does something worse. He kills her or something along those lines, right? If there's media coverage in that room, whoever's listening, whoever's making decisions on that case, let's say, for example, when the domestic violence initially happened, maybe they're going to be a little more conservative with the way they make a decision because they might be more scared to make a mistake. Maybe they might be more scared to release the person and then have something happen than if there's no media coverage. Because at the end of the day, I think that that's a major factor. What you don't want is you don't want to be seen as the guy who released someone and then that person went out and committed a significant greater crime.
All right. There's another person who just wanted to ask you a quick question because I'm not going to take up a lot of your time, but have you followed the Kyle Rittenhouse situation in the shooting in Kenosha, Wisconsin, or did you follow it at all? Did you see what happened?
Unfortunately, I have not followed it at all.
You didn't
so
follow
I'm looking at it very quickly right now. So if you want to tell me a little bit about it, I'd be glad.
Oh, okay. Well, anybody who hears me say this is going to say that I'm being biased, but very simply, this person, Kyle Rittenhouse, I believe he was below the age of 18. He lives in Illinois. He came to Kenosha, Wisconsin, I believe, where supposedly he works or something. He brought with him an assault rifle, or not, some people don't like the word assault rifle, but he brought with him an AR-15 style rifle, just like the one I have. And he decided that he wanted to, quote unquote, help out the police. So he, okay, he's joining right now. So basically, just to bottle this up, he decides that he wants to help out the police, and you can pretty much guess how that could quickly turn into a case of vigilantism. But anyway, he was ultimately charged with the shooting deaths of two people. They're ruling it, they charged him with 2 homicides. One of the other guys supposedly came at him with a pistol. I believe was in self-defense, but the jury is going to.
No, he's a felon. He was convicted felon. He shouldn't have had the firearm in the first place.
Let me just finish. So anyway, he shot this guy in the arm. And when he shot this guy in the arm, it basically destroyed his arm. So this person was wounded rather than killed. So I don't know if you had heard of that situation or paid any attention to it. It is my belief that Kyle Rittenhouse is definitely going to end up going to prison. It seems like we don't seem to have any laws specifically for vigilantism.
Can I give the real thing and not the
bias bullshit? Go ahead and try to bottle it. But hold on.
I will. Real quick.
I will. Mr. Gonzalez, Judge Gonzalez has given us a lot of time. Thank you.
Okay, I know. I'm trying to be quick, be quiet. Hey, thank you, Judge, for being here. So let me give you the non-biased situation. All right, so what happened was, again, Kyle Rittenhouse, I think he was like 17 or something at the time. He lived within the subsidiary of the main city where he was. Him and some people were there for the protest. They were armed with long guns, not handguns. They were out during the protest, protecting properties and things like this. They were approached by 3 different individuals that were all the aggressors. In the first situation, Mr. Kyle Rittenhouse retreated. He ran. There was a shot fired. He didn't know where the shot came from, but he turned around. Someone trying to lunge towards him, disarm him of his firearm, and shot that person. All rounds on target, killed him. Then he ran to get help. Okay. In the process of him running to get help, there were other people around that were quote unquote protesters or rioters, however you want to look at it. And they tried to again, they attacked him physically. They disarmed him with the they disarmed him, tried to disarm him with a firearm, hit him with a skateboard. He shot that dude, killed him. Then the other guy that came up and pulled out his handgun to try and shoot him, who was a convicted felon who shouldn't have been in possession of a firearm in the first place, tried to shoot him, and he shot his arm bicep off and pretty much like turned his arm into spaghetti. And then they arrested him for the murder charges and what's name, mind you. 2 out of the 3 people were convicted felons. And in all situations, Mr. Kyle Rittenhouse was clearly in a position of self-defense. He did not engage anybody. He did not fight. He did not strike a blow. He did not do anything. He was treating in all of the situations, and in all other situations, he was the first one being attacked before he fired upon his aggressor.
All right, so but okay, so you're about to answer because I really don't know how much of the background you have, but here's a question. Oh, okay, he's just talking.
He's muted.
Yeah. I think he's talking to somebody in the background for a second.
Sorry, I was talking to you.
He's muted.
Oh no, okay, but here's a question.
Wait one second. I want to stop you there. I'm actually not allowed. One of the rules is I'm not permitted to comment on cases that are in front of any other judges right now. So I actually literally.
Okay. So you can't talk about it legally. Okay, my bad.
Yeah, so if it's a case that's closed or something that's already happened, then I'm permitted to talk about it. So, such as the situation, with in Minnesota.
Well, let me ask you a question in a hypothetical. Okay, so I've got a rifle, and I decide that I'm not happy about people who are rioting in downtown New York, right? New York City.
He just said he can't answer.
No. I said it's a hypothetical, and I'm using myself. This is hypothetical, purely hypothetical. So if I take my rifle and I say, you know what, fuck these motherfuckers. You're not coming around my office and starting no shit and breaking windows and shit. And I take my rifle down there and I decide to stand around and quote unquote help the police. Or I got a first aid kit and shit and I'm dressed as if I'm fucking like Secret Service and I'm trying to help the police. So hold on. If somebody decides that they think that I'm on the other side of a political issue, and they see my weapon because I'm wearing it around me, and it's visually intimidating, and somehow I get into an argument or fight or argument with them, and I end up shooting and killing 2 people, despite the fact that I could have stayed home. I wasn't supposed to be there. And I shoot and kill 2 people and wound a 3rd. This is hypothetical.
Listen, man,
you
can't comment on it.
No, why do you?
I think you're getting close enough to, it's
okay.
Let me ask this question. Let me ask another question. Why are the trial courts so horrible at getting things right? Why have they made things like a business instead of worrying about? Why does the appeals court always have to? Why the lower courts on the federal and the state level so lousy at getting it right?
I don't know that they are. I think that they do the best that they can. Every court does the best that they can with the information that they have presented before them. And to be honest with you, I think for the most part, I want to say more than 9 times out of 10, they get things right.
Okay.
That's just my opinion. Now, there was a question also asked that I didn't get to touch upon. It was, how has the court system changed since Biden became president? I can tell you that generally, I think we have a separate judiciary for a very strong reason.
Yeah, thank you for addressing that, because as far as I know, the presidency has no control over the the judiciary.
None whatsoever. So regardless of whom the president may be, the courts continue to operate as a separate and autonomous branch of our federal government. So I see no change and no effect. So I think while people sometimes assume that these changes, they're major changes, obviously, a new president, that's a big thing, right? The ideology might be different. I think they fail to realize that our country is created in such a way where it's purposely separated. So whomever is that figurehead really doesn't have as much power over things below them as one might think. So, for example, with the court systems were not affected whatsoever. I can't speak for everyone and anyone throughout the entirety of the United States, but I don't think that any judge literally, it was affected in any way, shape, or form by whom the president was. Perhaps now, if we're talking about Supreme Court judges, that might be obviously a little bit of a different situation because, for example, if a new president gets to appoint Supreme Court judges and there's an opening, etc., that may be in effect. And that, in essence, would be an effect that the president would have on the judiciary. But that president does not affect in any way, shape, or form how that judge, once that judge is appointed, makes any decisions, nor can the president affect how that judge makes any decisions before they get elected to the Supreme Court or before they choose them as a possible candidate for the Supreme Court.
Okay, real quick. Is there ever going to be a time where there's going to be able to separate public opinion from affecting the outcome of trials? Or the court system ever going to take ways to do that?
Well, I think, okay, so again, we're going into just my opinion, right? Because there's no real right answer here. I think for the most part, people think that public opinion affects things much more than it really does. Because let's look at some real stats. These are not exact, but they are very close to and very real. 9 times out of 10 or 99 times out of 100, most cases do not go to trial. They're settled prior to trial, right? Mm-hmm. And when you're really looking at public opinion, you're really looking at issues at trial. How does the court finally make a determination? How does things along those lines? Because otherwise, up until that point, you're really only looking at minor decisions and or a plea deal, right? Or plea negotiations. Now, if there's media involved in a case, for example, let's say, again, I'm going to pull something out of the air. Let's say there's a child abuse case, right? And that there's media coverage over that child abuse case. The prosecutor who's handling that case is probably, in all likelihood, going to be much tougher on the situation than if there were not the media coverage, because at the end of the day, they're afraid of perhaps looking weak or, like we mentioned before, making a mistake and maybe giving a more favorable plea deal, and this person then goes out and commits another crime. So in essence, I think that the media coverage or the public opinion portion of things, which you can't really separate from media coverage because there is no public opinion without media coverage. Because, I mean, for example, let's say you gave a situation of your case, right? Without media coverage of any kind, do you think anyone would in fact know anything about your case? No, right? It's only the people immediately near you that would know because you've told them. But once you get into media, then public opinion, unfortunately, it can affect things, but not necessarily. Well, that's not true. I was going to say,
you know what?
In a good way. It can affect things both ways. It can affect things in a good way. It can affect things in a bad way. For example, if it's a terrible situation like a child abuse case, the prosecutor might be much more difficult. But I have heard of cases where, for example, a young man was charged with murder, and it was clear based on the facts that he was in fact defending a relative. And it was pretty clear. The facts were made out and the facts were presented in such a way where anyone reading the story had a good gist that this person was defending themselves. And that public opinion, I think, in essence, affected things more positively because I think, well, it may have been the public opinion or it may have been the fact that the prosecutors and the court, in fact, were aware of the actual facts, right? So
let me say something, because I think what they're really trying to say, it's just in how they're phrasing the question. I think what they're really trying to say is what they're really trying to do, it seems, is they're expressing that they're not happy with the fact that unredacted, uncensored videotape footage can be used or manipulated by, say, the media in order to affect the outcomes of cases. Like, for instance, somebody brought up George Floyd. I am 100% certain that if it hadn't been for that videotape that showed that cop kneeling on this guy for whatever amount of time it was, that he may never have even gone to trial if it hadn't been for that videotape. But we now have a system between YouTube and the iPhone in my pocket where I can videotape an officer, or I can videotape anybody doing just about anything, and I can release that information to the internet and let the public be a judge. I think in the law, don't they call that like poisoning the well, when you've put out so much negative information that the defendant can no longer get a fair trial?
If I think that if any person feels that they're not able to get a fair trial because of a public opinion situation, then they can move to have their trial relocated to a different place, heard by a different judge.
Yeah, but not a different country.
That's not a different country. But again, we're looking at, I think what we're saying is what I was trying to say before, is you're looking at such a small percentage of the reality of things that it's really usually not especially relevant for most cases, right? We're looking at exceptional cases. And I think, like you said, the George Floyd situation, may have turned out differently, but it's exactly what we talked about before. The judge can only go by what evidence is presented, right? And the judge can only, again, prosecutor can only go by what evidence they have presented before them, what they have available to them. So to say that the outcome was affected by the video is almost, I mean, that's what should happen, right? That's exactly what should happen. It should happen that if you have evidence and you present that evidence, the court should take that evidence seriously. The prosecutor should take that evidence seriously. But if you don't have the evidence equally, maybe there should be a middle of the road determination, or a middle determination, because honestly, I don't know if you're, okay, let's use a really easy example. Let's say you're a parent and you have two kids, and two kids come up to you and say, and that's honestly, being a judge is sometimes very much like that. It's listening to the perspective of two different people, as if you had your two kids coming up to you and saying, Daddy, so-and-so did this, he did this, and the other person saying, no, I didn't, and they're going back and forth. That's literally the same. I'm not saying that the people in court are children. That's not what I'm saying at all. What I'm saying is that the dynamic is very similar, right? So as the parent, this is something that many people have experience with. What do? You look at, for example, I don't know if any of you guys have seen this, but there's videos. There's funny videos of children. Parents are taking videos of children. The parent says something to the tune of, you ate that candy, didn't you? Or you ate that ice cream. And the kid has chocolate ice cream all over their mouth, saying, no, I didn't, Daddy. Now, you're listening to the kid say that, but you're seeing the evidence right on their mouth, right? So obviously, you're going to make the assumption, the logical leap, that it's more likely than not that the kid ate the chocolate, right? But if the same scenario happened, chocolate's gone, child comes up, you come up to the child and you say, hey, did you eat the chocolate? Now there's no evidence of that happening. Now you're in a little bit of a more precarious situation. It's not as reasonable for you to make the jump. Now you have to look at other facts. Were there any other people in the house? Did you actually, in fact, place the chocolate on the table? Was it where you thought it was? Maybe you made a mistake and you placed it somewhere else. So in the absence of evidence, it's much more difficult to make decisions. And it shouldn't be that we negatively think of, let's say, for example, having this video evidence. That's not a negative. That's actually
a positive.
It's a great thing.
This person Roscoe says, didn't you say that eyewitness evidence is the worst kind since people see what they want? But I don't think what he understands is this wasn't just eyewitness evidence. This was video evidence.
That's correct.
That was presented to the jury, the court, and the world. So even though you wanted this situation to turn out different, that's not what happened.
Correct. And the reason, let me be exact here and clarify. Eyewitness testimony is usually the worst type of testimony, and it's simply because we just talked about how sometimes cases may take 5 years to get to trial. The reality is that how accurate do you think your memory is from today, something that happened 5 years ago? I don't know about you, but as a normal human being, I would say if you were to start questioning me about something that happened 5 years ago, my memory may not be great. I might remember things a little bit differently than they actually happened, or I may flat out make a mistake. Right? It's quite possible. It happens quite a bit, and for the most part, also there is identification bias. There are several theories that say that even if you're questioning a witness on the scene of something occurring, the likelihood of that person making an error in judgment or making some error is still pretty high. So just because there's an eyewitness doesn't necessarily mean that it's a slam dunk against a person.
Well, is there anything else, Ramil or Mr. Fantastic?
No, nothing I could think of. No, not right now.
Mr. Fantastic?
I guess what's his take on is he familiar with family law in any way, shape, form, fashion?
Wait, what'd you just say?
Family law. Does he have any background in family law whatsoever?
Well, you can ask a general question. This is all just about opinion. I can't give you legal advice anyway.
Well, no, it was just opinionated. So it's sort of like what Ramil said. So what's the issue and reason for them having separate courts for child support and child custody, even though they're, both dependent upon each other?
That's a great question. And again, it's going to be an opinion question because there is no right or wrong answer. I do know, though, however, that initially the thought was that the finances should not affect the visitation and custody portion of things, especially the visitation. Because the fear was that it depends on where you are, right? So let's start with that. I'm going to speak to having read some background about New York and some other states in the immediate area. The reasoning initially was that they thought you should separate them because, for example, if you're a father, which unfortunately that is most of the time the case, it's the father that's being charged with child support and looking for visitation. The fact that you're not able to pay for support should not, or that you have some limitations on support, should not affect negatively your ability to see the child. So they try to hear them separately so that the person making the decisions can't be impacted at all by one or the other because they don't know anything about the other case. So, for example, if I'm the judge listening to a child support case, now, you bringing up issues of visitation and custody, those are not necessarily relevant to me, and I don't need to hear them. I'm making a decision just about money. So only financial things are important, and you present to me only financial things for me to make a decision. Now, with regards to visitation, the financial part of it is not important to me. You do not bring those things to me. I do not want to hear about the money. Whatever you and your other party have worked out about money has nothing to do with me. I am only here to make a decision as to when you should see your child, if you should see your child, and with what frequency you should see your child, right? And the fear is, for example, let's say someone is able to pay $25 a month, which might be the state minimum in some states, right? Let's say one person's able to pay that and another person's able to pay $2,500 a month. Should the father who can only pay $25 a month be treated differently than the father that can pay $2,500 a month? No. A father is a father, and a father should be treated equally no matter what their ability to pay support is. So I think the theory behind separating them is just exactly that. But regardless of what you can pay, you should never be prejudiced in your ability to see your child. Does that make sense?
Makes sense to me.
Yes, sir. Greatly appreciate that.
Okay, so it is 7:54. I suppose we'll be wrapping up soon. I don't know if there's anything else pressing. The Leonson, did you have something, short question you wanted to ask?
Yeah, kind of to piggyback from what Mr. Fantastic was talking about in
Okay.
the
All right.
the family law.
Yeah, just bottle it nicely.
Yeah. So as a judge, I'm guessing, like, have you ever taken any family cases at all?
No, but again, wouldn't matter because I couldn't give you a legal opinion anyway. So it would be just general, right? Just general conversation, two friends having a conversation.
All right then. So So, all right. So I won't ask you the first one. So my second one then it was still family law. Like, why are some court like decisions or like guidelines still back in the 70s? Like, for example, with the family law again, like the whole oh yeah, she leaves you depending on what state you're in. She leaves you for like a year. You have to pay her for life. When obviously she's an able-bodied human being, she could definitely get a job on her own and support herself. Because I understand the idea of what it was back then, but that's not it is in the case of what it is now. So why isn't there an effort to, just in your opinion, to like accelerate it to what it is, like,
Sure.
or to what it should be, or like a fairer system?
Well, I think that the law is constantly changing, constantly. It doesn't ever stop changing. It evolves, right? And many things within that area are evolving. They're changing, right? The law isn't exactly the same that it was 5 years ago, 10 years ago, 15 years ago, 20 years ago. So, for example, just something coming to mind that I read recently. Up until about 5 years ago, in certain states, if you had an advanced degree, that's something that could be included as property in your divorce. So, for example, let's say wife and I get divorced. I have a law degree. She has a medical degree. I could theoretically take a portion of. I could have taken a portion of her medical degree and she of my law degree, right? Or worst case scenario, one of you has a professional license or a professional degree and the other one doesn't. That person that doesn't used to be able to take a percentage of your earnings from that degree under certain circumstances. The law then evolved to remove that, thinking that it was unfair. So it's tough. The law continues to evolve. It does, however, evolve very, very slowly. It literally moves at the pace of molasses for the most part, right? And unfortunately, from what I know, many of the states have guidelines based on percentages and not actual numbers in certain circumstances, right? That wouldn't necessarily have to change because the percentages they're not real set numbers. Now, if I'm correct, where you're asking for is, for example, lengths of support, lengths of maintenance, right? Now, that's going to vary state by state. And unfortunately, I think that there are reasons why many people opt to not get married. There are many reasons why people opt to not get married, for example, in one state or another, or opt not to get divorced in one state or another. And that's usually dictated by the law in that particular state. So I think, unfortunately, I mean, it's just, there is no real answer to that. I'm sorry to say. The answer really is that it's just something that you have to deal with. So the better way to possibly address it is to address it with maybe an agreement with the person beforehand, before ever going that route. Now, if you're looking at child support, for example, most of the states have a set time frame for which the child support would be due. So that's not really changeable. That's usually held hard in statute. So I don't think there's anything you can do about that. I don't think there's anything you ever will do about that. The law, I doubt, will ever change with regards to child support in that sense. Now, with maintenance and support of your ex-spouse, that's where we're looking at a continued change and a continued evolution. But I hear your point, and there are many people that agree with you and have that same point. And there's fathers groups, that are trying to make changes in the laws state by state. But I'm not sure where we stand, and it's going to be hit or miss. You're going to have different states making changes. I see that in the future, but I don't know where they're going to go. And unfortunately, even as a judge, even as a person within the system itself, sometimes we don't know what the legislature is doing. Just like we talked about before, the president has no effect on the judiciary. The judiciary has no effect on the Senate and the Congress, and with regards to the other factions or the other portions of the government. So they make their decisions and they don't consult us. And those decisions affect us. and affect the way that we make decisions, which in turn affect the people that we make decisions against or for. But the reality is that we usually don't have much input in those decisions, if you understand what I'm saying. So it becomes an issue of what is the best way to affect change on that end. It's going to be those lobbying groups, those fathers groups who are lobbying their congressperson, their senators, their state senators, their local politicians. It's going to be that, because that's realistically where the change is going to come. Once you're looking at a change to a law or to a statute, especially in that area where they're so set in stone, it has to come from outside of the court system, because what a judge can do is a judge can change the way they interpret the law, right? But the way I interpret something can only go but so far, especially if, for example, let's say a law says child support is due until a child turns 21. There's no way for me to interpret that any differently, right? I can't say, well, 21 doesn't really mean 21. Sometimes 15 means 21 or 25 under certain circumstances if the child is going to college. I don't get to make those decisions.
So basically, child support's a mandatory minimum.
It's basically for most states, as far as I'm familiar, I think that's right. And I don't think that's going to ever change, because I think that most states are interested in protecting the child over either of the parents. So if you're going to battle father, mother, and child, the court is always going to hold the child in a higher position and try to protect the child, even to the detriment of the two other parents. So I've been told, I've had conversations, again, people have conversations. I have conversations with friends. I've met with attorneys that do handle family law or matrimonial law. And many of them have said things such as, they've heard judges say, or people have said, there's no way I can make that payment. What do you expect me to do? And sometimes judges will actually respond and say, well, get another job or cut your expenses. Because the logic is, what? This is what's required to support your child. That is what is going to be required of you, just like is required of everyone else. Now, if you have to, for example, maybe your rent shouldn't be $4,000 a month. I'm just using a random number. I hope that you're not taking me to that. And the judge may say, maybe you need to live in a place that costs half as much, so you can apply that $2,000, the extra $2,000 missing towards your support obligations, right? Maybe you don't need to take 3 vacations per year. Maybe some of that should go. So many times, again, we go back to people testifying and thinking that their testimony is going to make a difference or will help them. And many times it doesn't, because most people will think, well, I can't pay that much because my expenses are X, Y, and Z, and they list them out. And, if you're a decision maker in those situations, I think where you're stuck is you're stuck with the law. You're stuck with, let's say, 21%. Let's just use that random number as a child support obligation. And I can't do anything other than issue an order that says 21% of your income. So the only thing I can tell you at that point, if you tell me my rent is this much, I pay for my car, which is this much, I go on vacation, which is the only thing I'm left that I can tell you is literally, then if I can't change the number that I'm making you pay, the only thing that you can change is the expenses that you're paying every month, so that you can make the order you have to pay more reasonable or palatable for you. But people don't generally want to hear that. They don't want to hear, maybe you need to cut expenses to pay your child support. Generally, what they want to hear is, oh, well, maybe we'll figure it out so that the support goes into something that fits your budget. But that's not the reality. The court doesn't look at it that way. The judge will never look at it that way. And regardless of what your situation may be, you may lose out. You may be in a situation where you're now at a different apartment and a different house, where you're not eating out as much, where you're not paying for as nice a car, where you may have to unload of all of these things so that you have the finances to pay the support. And unfortunately, that doesn't work for most people, and I don't see that ever changing. But, if you're interested in the father's perspective, I would suggest looking into some of those lobbying groups and talking about the issue of how do you change how long you're obligated to pay support to a spouse for. That is something that's being worked on right now.
All right.
Somebody did say, where can you find them?
Yeah, I think
Google.
that's going to be a Google search. It's unfortunately there are many of them. There are just so many groups. They vary state by state. I don't want to name any one in particular because it might not be relevant to your state or to your city. There's just a vast number of these. The only thing I would suggest is be very cautious, because anytime you have something like this, I've heard of people charging money to join things like this. And the reality is that unless you're hiring a lobbying group or unless you're paying for an attorney services or something, this should be more like an opinion situation where you're discussing things and presenting your ideas, right?
Okay.
Now, there are some that are hiring lobbying groups, sending them out to Washington or to Albany or to other places. In that sense, then maybe you might, as a member, you might have to chip in some money to cover the cost of those lobbying firms or those attorneys or whoever it is that those people are hiring. But you shouldn't be paying just to be a member, just to be, usually from what I've heard or from what I've seen, usually the ones that do that aren't really doing anything, and they're really meant more so for creating revenue.
Okay, and
so
we announced that you had one last thing, and then go ahead.
Yeah, this is my last one. Somebody put this in the chat. I was gonna ask him anyway, but like, why? This
I wasn't really touch on the payment itself, but say for example, you said the 21%. Why can't that 21% be to both parents, and then put that 21% into an account where it's like everything that comes out of the account is like documented.
Okay, so
I think it sounds to me like he's asking, how does he make sure that the money goes specifically to purposes that have receipts, and the mother can't use it for wigs and fucking hair bonnets?
Yeah, I think that's a tough question, and you're not going to like the answer. There's no real system for that. The only thing that's required is that you pay your obligation under the law. So, for example, let's say you get a ticket and you pay that ticket. You really don't want to pay that ticket, right? You're not happy about paying that ticket, but you'd like to make sure that the payment of that ticket goes to something productive. The reality is that you don't know where the money is going, and you don't know, and it may not necessarily go to what you would want it to go. And this is not a great example because obviously support of a child is very different, right? My point, however, is that it's similar in the sense that the law just requires you to pay the obligation. That's it. The law doesn't look into where things happen with it, at least from my opinion. And I think, many people have taken the position that that's difficult, that's tough, and that it's not great, right? And it shouldn't be that way. And people have asked for reform. The problem usually with that is that you have to, from the court's perspective, I think what might be happening is that perhaps they don't want to basically track something. It then becomes too difficult to do that, right? It becomes too difficult to continue to show, for example, once a case is over and there's a decision issued and it says you pay X amount of support, if then there's a supervisory role for the court now to ensure that the funds are being paid for specific things, that now creates judicial involvement for the rest of the child's life until they become an adult. And I don't think that that's what anyone wants. So unfortunately, the only thing you can do is pay your legal obligation and then hope that the other parent uses it appropriately. Now, does that always happen? No. Right?
But isn't it involvement no matter what? Because like as soon as you go to the court is involved in the child's life. Because not only because you're making a decision for the father, in this case, the father to pay the 21%.
So
that means you're already involved.
Yeah. So let's pretend. Let's say a judge issues an order and says you must pay X amount percent. Right. That's what you must pay. Now the case technically ends at that point. Now, unless there's an issue and that other person says you didn't pay and brings a new case, a violation, then nothing happens. There's no further judicial action necessary. However, what you're suggesting, it would basically be the court would have to keep the case open because they would have to keep tabs on a regular basis to ensure that the money is being spent the way that it should be. And I don't think that that's something that the resources exist for, unfortunately.
All right. Well,
Yes.
it's 8:10, and we may have taken a little more of your time than I expected, but we went for a nice solid 2 hours. How did you like the format of doing this with StreamYard? I'm sure you've done Zoom before.
Yeah, this was nice. This was very similar to Zoom. It's pretty much the exact same thing, actually.
Oh, okay.
So yeah, it was nice. Thank you for having me.
Yeah. So, do you have any closing thoughts? Somebody did ask, what do you recommend as far as if somebody wants to get into a legal career? They asked that at the very beginning, but I don't know.
I think it's a tough call. I think the legal profession is very hard. It's not for everyone. I think that it's glamorized by TV and media, and it's not necessarily as glamorous as it's made out to be. So yeah, there you go. So I think that the best thing that a person that wants to study anything should do is intern with someone, get to see what it's actually like and see if it's for them. And if it is for them, great. At least you now have some knowledge and you're making an intelligent decision. Let's go back to what we said before. You want to make you want to make a decision based on evidence, right? The only way to get the evidence would be to get experience and to get contact within a particular field. So I think that the only thing that I can advise you is to see for yourself. Go in, try, work, volunteer, do something that would give you an opportunity to have some contact with the field of law, for example, if you're interested in going to law school, that you would want to study. Because I think what most people don't realize is that, again, the glamour thing, but the practice of any field is probably not the same as one imagines it without having any experience.
All right. Well, thank you, man. We really appreciate everything that you brought to us today. Everybody in the chat was basically saying thanks a lot for coming on. We really appreciate you. And hopefully, maybe sometime down the road, if you're not busy, we'll have you again.
Sounds like a plan. Thank you.
All right. Well, thanks a lot. And everybody, thanks for joining us. I hope the few questions that you guys were able to pose, I hope we were able to answer them. And thanks a lot for joining us. And with that, I'm out.
Thanks, everyone.